there, this is BQ Prime, and you're watching the Fineprint. A lot is happening in the tech regulatory space in India, and our effort on this show is to deliberate upon those changes and their potential impact. To that end, today we are discussing a recent thought provoking consultation paper by the Department of Telecommunications. And I'm joined by Rahul Matthan from Trilegal to understand what this new policy framework might look like. Rahul, welcome back to the Fine Print.
Thank you.
Rahul, before we come to what the policy framework will look like or the consultation paper says, the positioning of this consultation paper is that, look, we've been working with a law that's been over 100 years old now, and we need a modern law for the modern technology. What we have today is the Telegraph Act, which of course has seen umpteen amendments and court rulings govern the sector. Do you think that the sector today, we've seen massive consolidation in the last several years, has suffered as a result of this relic policy?
Look, obviously, we've got an extremely successful telecom ecosystem. We have a billion connections, 600 million smartphones, some of the lowest tariffs anywhere in the world, great data
Great for
opportunities.
users.
Great for users. Not so good. I know the question behind that. There's been massive consolidation. Many players have left the market. But equally, one would argue that having something like 11 players, or in some times there were up to 14 and 15 players in some circles, is insane. That's also not good. And so now we've moved down to, around the world, people are consolidating from 3 to 2. We're roughly in the same space. The telcos have had a really rough time with the AGR case and all sorts of things. So yes, it has. I guess the telcos have, in a sense, suffered. But I think even if the sector has grown a lot, I think they've grown with a lot of pain because the regulations are really difficult and challenging to deal with, and just the framework is a challenging framework to work with. And so I think the timing of this consultation is actually very interesting. We're seeing that there's work happening with the Digital India Act, which is around the IT regulatory sector, where obviously
which will eventually replace the information technology rules, intermediary rules.
And I think the whole IT Act.
Yeah.
And then we've also got the privacy law, which once again is imminent. And at the same time, looking to recast the way we think about telecom is an interesting move. I mean, I would say that we've expanded. Now we've covered the entire country. We've had a lot of innovation in the way we've done it. We've had a lot of efficiencies brought in through sharing of infrastructure. When we started, there was no sharing allowed. Now pretty much everything can be shared. So we've evolved the sector and got to this current point in time, in many ways, despite the regulatory framework.
Yeah.
But now it's time to really consolidate this policy framework and make it, I guess, forward-looking. I mean, we've got to start now saying, look, we've covered the entire market. Now, how can we get efficiencies into the regulation such that we can regulate what we have to regulate and allow the market to do what it has to do? And I think that's sort of the way where we are.
So the DOT says we now need a modern and future-ready framework. What principles do you think the DOT and the stakeholders should work with to that end?
Look, I mean, I think there are two ways to think about it. I think one is substantive and the other is structural.
Yeah.
As you mentioned, we've got the Telegraph Act. The Telegraph Act, by the word telegraph, was designed to govern telegraphs, which, if you recall, the way you communicate on that is using Morse code. Now, that regulation, thanks to the British, just the expansive way in which they drafted, has held good all the way till today, where we're now governing the internet, we're governing voice over IP, streaming, all on the same framework. The basic framework is the same. And the way we did that was we had this law which had some very basic provisions, and it allowed different services to be licensed. And so the regulatory framework today is essentially a basic law with a lot of licenses. I think 23 or 27 licenses, different types of licenses. And that's a very cumbersome framework Because if you want to make a change to the substantive provision, if you want to introduce, say, new security provisions or something like, you have to make it in 23 or 27 different licenses, and that's very cumbersome. And licenses are issued for a period of time, so you have some people whose licenses are valid, some whose are expiring, new people coming in. It's a completely disjointed framework. So you had at a particular point in time many people on the old license with some arbitrage because they came in early, and new people coming in on new licenses. So it's a big mess. This is not the way to run a system. And I would say structurally, the first thing that we need to do is to make a law, have all the regulations in that law, and just remove this vast plethora of licenses. Put whatever you have to put, which is service specific, into a set of regulations, and then have people sign up with a very simple form to say that, look, I'm going to do, I don't know, I'm going to be an ISP, which means I'm going to provide data connectivity, not voice, to end retail consumers. Or say that I'm access, which means I want to do voice, data, the whole shebang to retail customers. That's a simplified, simple way of operating. The changes that you need to make, because you will have to make changes. Technology changes and evolves, and you will have to make changes. You can make it in the regulation. And that regulatory amendment will apply to everyone in the sector without having to go license by license and amend them. So I think that's the fundamental structural change that I would make. And then substantively, I think, historically we've had many reasons why we've placed restrictions on the way in which services could be provided and the types of services that could be provided. So there was a concern that, if you remember, previously we used to have the whole country divided into circles.
Yeah.
And then if you wanted to make a call from one circle to the other, it was a national long distance call. Okay. People today don't even know what that means, because it costs the same regardless of whether you're making a call across the road or you're making it across the country. And so that whole concept of national long distance is irrelevant today. But along with that, there were additional challenges with regard to how do we ensure that people don't sidestep this. And one of the ways people were sidestepping it was using voice over IP calls. So getting a data connection, but making a Skype call, and then bypassing the NLD revenue. Now, all of this is completely meaningless today. So I would suggest that we remove all these distinctions. Don't have circles. It's not relevant. It may be relevant from a spectrum allocation perspective, but that's very historical. There are ways to conform all of that. Don't make a distinction between voice and data. Already all telcos are optimizing it. They're deciding where they have coverage, where the coverage is better with the cellular network, and they will send the call through that. Where it is better over a data network, they will use, Airtel I have an Airtel connection, so it's the Airtel connection every now and then says Airtel Wi-Fi.
Yeah, so let's say within a particular space, you can just connect on a Wi-Fi call.
And do it on the fly. Yeah. Whenever the cellular network is getting jammed, use the Wi-Fi and vice versa. Yeah. Right. So, I think the technology specificity of the existing license regime right now is just regulatory arbitrage. It's an opportunity for the regulator to come and just put pressure on you. Why are you offering this service over IP? Why should it matter? Today, there's no difference. If I have a mobile phone, I can either make a WhatsApp call or I can make a cell. It doesn't matter. It depends on where I have the coverage. Yeah. And I think that sort of arbitrage needs to go.
Okay, so while the first half of this consultation, which talks about how spectrum as a resource should be allocated, and the fact that we need a future-ready and a modern law, we can't work with the Telegraph Act anymore, and there are sort of efficiencies that we need to be able to achieve because we've just become such a big market. Yet there is language in the consultation paper that suffers from a baggage when it comes to spectrum allocation, where the language or the approach seems to be that, yes, it's a natural resource and it suffered from lapses in the past. We need to continue to license it in the most efficient fashion, and there is revenue considerations for the government. Do you think that we'll be able to shred that baggage at all, or do you expect that this new law will take a different approach to allocation?
So one is there is baggage. I mean, we've got spectrum that has been allocated in the past, and we can't just wish it away. Whatever it was allocated, we just have to uh, now create whatever new law we create. We have to create it in a manner that accounts for those previous allocations. That's the one thing. The second thing is it is a scarce natural resource. There is only so much spectrum. Of course, what's happening is as technology is advancing, we're finding newer and better ways to be efficient about the spectrum. But spectrum has certain characteristics. If it's 800 megahertz spectrum, it's great for distance. It's not so good in terms of how much you can load onto the tower. But if you've got the 2 gigahertz spectrum, you can load a lot onto the tower, but it doesn't go very far. And so you have to use the spectrum in the appropriate way for what it was intended to. As you recall, the early spectrum auctions were all in the 800 megahertz rate, and that was great at that time because we had to roll out this network and we had to reach as many people as quickly as possible. Now everything's in the 2 gigahertz and above spectrum because this is what we need for things like 5G. So I mean, I think so that's the one thing. I think the other thing is that we can't just go off on our own and allocate spectrum in the way we choose, because our spectrum has to work on mobile phones that work around the world. And so we have to do whatever the ITU is doing around the world in terms of this is what this band of spectrum is used for. So these are the constraints that you have with spectrum. But I think one of the things they mentioned in the consultation paper is that they're going to do refarming and repurposing of spectrum, which is what we really should do. Okay. I mean, there's some spectrum that was used for television broadcast, terrestrial television broadcast. That's no longer relevant because right now almost all broadcast is satellite or cable, and that's completely different.
Cable also little, but mostly satellite.
So there's no need to earmark that spectrum. And if we've got new technologies, and lots of people are making technologies that use that spectrum. And so we should constantly refarm and repurpose. There is advantage in actually having contiguous bands of spectrum. So we should reallocate spectrum such that operators have contiguous bands of spectrum so that they can use that even more efficiently, as opposed to, because of different auctions, they've got different pieces of spectrum and they're not together. I think, to be honest, the DOT has done a lot of that already. So a lot of the spectrum that's held right now is in contiguous bands, which means we're operating at high efficiency as far as that's concerned. But I think we should really look to repurpose spectrum, and I think that is a forward-looking.
Okay, so they talk about spectrum allocation. They talk about new technologies like IoT that need to be governed and have a framework for. They talk about M&A in the sector. They talk about when, let's say, a player goes into an insolvency court, how that resource that was allocated to that player should be dealt with. What sort of, commercially speaking, how will these ideas, or how should these ideas manifest? Because as you're saying that despite the law being how old it is, we've managed to innovate and managed to find way around it. So to be able to, so this new law, do you see that as a consolidation of all the regulations, or do you see some path-breaking ideas there?
Well, I'm hoping there'll be some path-breaking ideas. I think the consolidation of the licenses is important. Okay. So we have a number of licenses that we shouldn't have. They're just pointless. They're on the books addressing an issue that was an issue earlier, is not anymore. So those have to be eliminated. We have a lot of licenses that, because of this technology neutrality issue that I spoke about, because we were not technology neutral, we've created licenses where it's not required. And then we've got our licenses that, just for various reasons have been called what they are. And so there are distinctions between things that really shouldn't have a distinction. So for instance, the National Long Distance License, which is essentially a carriage license, a license to carry traffic from one circle to the other, is also the license that you use to provide network connectivity to enterprise customers.
Okay.
Now, why would you have to do that? Why can't we just break the license regime into those to do carriage, which is essentially those that carry the traffic between telcos, and those that provide access, which is those that provide the telecom service to the consumer. The consumer could be a retail customer like you or me, or it could be a company. Why do we have to make that distinction to say that NLD operators can provide it to companies? It makes no sense to me.
So you're saying once you've given the license, allow the player to do what it wants to do with it.
Break it down into carriage and access.
Okay.
Access is customer facing. And so the access part of the regulation should deal with things like traceability, security issues. These are important issues. If every telecom regulation anywhere in the world has got some sort of a security feature. But why should the carriage players have to deal with this? Because the carriage players they should be just dumb pipes that are carrying the information across. But our NLD licenses do have these sorts of conditions.
Okay.
So I'm saying we should rationalize things in this way, try and find out what's required for what purpose, and absolutely don't dilute the impact of the regulation, but apply it more sensibly. That's sort of the way I would think about that.
Okay, and while you said that we're also looking at the Information Technology Act, we're looking at a Data Protection Act. Do you see this DOT effort result into more than what it is already regulating in terms of spaces, or providing for, or talking to the other legislations in that sense?
I sincerely hope that doesn't happen. And once again, I'm an optimist, as you know from every time you speak to me. In the ideal world, all three will talk to each other. Because I think if you take this framing, where you've got Digital India Data Privacy and the Digital Communication Act, you actually have three distinct spaces that need to be regulated separately. But there is a lot of potential overlap in all these spaces. If they're talking to each other and they're being written in a way that recognizes that the other exists.
Let me push my luck. Are they being written in that way?
I don't know. I mean, this is being held very close to the chest. Other than the consultation paper, there's very little visibility on what.
But I'm hoping that it'll be in a draft fashion, and stakeholders and
I'm hoping as well. I mean, ideally they should all come out together.
Yeah.
And I have no visibility on. I have no visibility on where the Digital India Act is, to be honest. We hear in the press that the minister has mentioned that both the draft telecom law and the draft data protection law will be out soon. And if they are out in that time frame, I would love for them, the teams, to have at least spoken to each other and recognize that, look, this part will be governed by the Data Protection Act. So I'm not even going to write up anything in the Communication Act for this. And this part, the Data Protection Law is going to say, I don't really care about this because this is a communications issue.
Yeah.
If we have that kind of interconnectedness between the regulations, I think it will be superb.
Yeah, so we've achieved interconnectivity in the sector. Hope in legislation as well. Thank you, Rahul, yet again for joining us with your views and insights on what the DOT effort might result in. And thank you so much for watching.